Hello, I want to call the Hopkinton Town Council special meeting of May 13, 2019 to order with a moment of silent meditation and salute to the flag.
I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Okay, we're gonna start this meeting. Not going to go any longer than 10 p.m. as usual, folks. Just give you a heads up as to what I want to do going forward on this particular meeting. We received over the weekend some information or updates on this particular project for the council to digest. We've done that, I believe. And I have some questions on that. Some of the councils may have some questions. So we'll have Mr. Epsigus explain some of the updates to the project itself. And I think they're being a positive light to the residents. Once we conclude that, question from the council, I'm going to turn it over to Jim Donnelly for his 25 minutes or so left of his testimony, something like that. And then after that, I don't know, Mr. Craven, I guess we could probably have you make your announcement or whatever you need to do, and then we'll open it up for residents. There's a couple residents that notified me that I missed at the last meeting. I'm going to have them first. I think it was 2 perhaps, and then we'll start with everyone else, if that's okay. The butters first, and then non-butters second. Okay. Mr. Epps.
Yes.
Mr. President, we also have Alan Benavides, my engineer.
Okay, great.
Mr. President, I've got some documents I want to publish to the council that these 2 gentlemen are going to speak to.
Okay, sure. So the memorandum, just so folks know, that the council received, it had 3 bullet points. It said, on behalf of the applicant, Skunk Hill Solar LLC, landowner, Hopkinton Land 1, Woodward and Curran is pleased to submit supplemental information based on comments received during the previous public meeting on April 22nd. The following changes have been made to the plans in order to increase the separation from the butters residential properties. Number 1, removal of solar panels in the area adjacent to the existing house on the eastern edge of Skunk Hill parcel, Plat 18, Lot 14. Number 2, removal of solar panels on the southern portion of Skunk Hill parcel, Plat 18, Lot 14. And third, relocation of the switchgear and associated electrical equipment from the southeast edge of the array to the center of 41 solar energy system, Plat 18, Lots 8 and 13. So, So I'll start with the rest of the council. I had some questions on what it was prior, how much separation did you make, if you can be as specific as possible. So does anyone on the council have any question on what we received this evening? That's me. Frank or Mr. Benavides, can you explain, I guess, on the separation you outlined as updates, what it was and how much you increased the setback?
So what I'll do first is I'll outline the changes and just show them on plans, that way it's clear. Unfortunately, given the set up the room, I may need to go up to the board to get updated distances there. But we've done 3 things. A couple we talked about last time, really all 3, but we modified the plans to reflect them. So the first one is right in here, and the panels used to go significantly farther south. We mentioned in the last meeting, men up here would be a butter, walk the property, find an area within which it seems to be reasonable to put the panels back. So that's the first change that we made, right in here. So these panels from the original application have been removed. We provided a couple second change is that based on feedback that we had at the, I think it was the prior meeting, could be the first one, what we've done is the switch gear used to be right here. It was somewhat close to some of the properties down here. We had feedback during that meeting regarding it. And what we've done is we've moved the switch gear into the internal portions of the site. So that's the second change. The last change, it came up kind of mid-meeting. There was some questions and concerns regarding some of the panels were down in this area. To reiterate what this drawing is showing, the dark green areas are the areas that are currently wooded and will remain wooded. And the areas that are in light green are areas that are currently open, and there's no trees there, and will continue to remain open. So right in here, these panels used to go significantly farther south, down to really the extent of where the open space is. And based on the feedback, when you pull these panels back, there was some discussion of where again. To reiterate, this is really at the concept level. What we propose to do is moving forward is to continue to work with town, work with the abutters. But these are three things that we've heard as the meeting's gone on and changes that we've made as the process gone on. So these panels in this area, where it's closest to home right here, have been eliminated. That was the most recent change.
Do you have any sense of how many were eliminated? What was the setbacks increased?
So about half a megawatt was removed in the last one, and I think some were moved over. Okay. So 300. So since the meeting started, we moved pretty close to a megawatt from the.
I'm not sure what that equates to as far as panels. I don't know.
Depending upon the power of the panels, that's going to be in the area of about just shy of 2,800 panels to 3,000 panels.
Between the two.
Between the two sections, yes.
And on that easterly side, can you just kind of read off, I guess, on the streets, what area of the streets it will be?
So this is a different drawing. This drawing, there were two that we prepared last time for you. One of the extent of the wooded area. I think the other one, the council women had asked for an updated plan with the butters. And so when we just did the update, we updated both of these drawings. So over in this area is Lisa Lane. So right in here, there was some discussion of some of the residents that live right here on these points.
Can you speak up, please?
I'm sorry. Okay. So, sure. So the changes, well, first of all, this drawing, there were two drawings. One of them showed the wooded area existing and what would remain active panel for proposed work you guys were doing. And then the second drawing is, this is an abutters drawing that came about as a request from the council members to have a better sense of what the adjacent properties were, what the distances to those properties were. So that's what this map is showing right here. Right in here is Lisa Lane. It turns the corner right here. There were some questions and concerns that were brought up with some of the neighbors that attended the meeting, the last meeting. So what we agreed to do is to, or what we've shown in these drawings, is to pull the panels. So all of the panels that were previously located in here, again about a half a megawatt, those were removed from the project. So Lisa Lane is right here. Looking out, it will continue to be the open pasture that you see currently is what will remain.
Thanks.
So using our calculator on my phone, 800 kilowatts using a 390 watt panel is 2,051 panels, which will be reduced off of the
2051?
205.
Okay, thank you. You guys have anything else for Mr. Benavides?
I do have a question. On the map that you showed, you may decide to jump up on the side.
Sure.
Actually,
Yes.
like, you might need the other map. However, what I want to know specifically is where you've removed the panels up on Lisa Lane. What I'd like to know is how far are the panels in that area from the property line of the others? And that's Lisa Lane. Lisa Lane and, yeah, Lisa.
So what I've done, and what I have shown on this drawing is the distance to the home, so let me give you that first. So the closest is 300 feet, and it's to 22 Lisa Lane, so that would be the closest home.
And the property line?
Approximately 150 feet.
Thank you. Second thing is, down on the lower one, near Francis Barber Drive, that's a flat 18-8 lot 8. That one on the southern end. How close are those panels to the nearest abutter's property line or abutter's house? What would be the closest one?
The closest, from the closest home to the panel is 497 feet. And the closest property boundary is approximately 70 feet. Pardon me? 25.
What's 25?
Yeah.
Oh,
Yes.
what I'd like to see, if this is going to go forward, I would like to see the distances from the panels to the property line be 300 feet. That's what I'd like to see. So I'd like to see the, down Francis Barber, that's going to be more. Up on Lisa Lane, it was, I believe you said 150 feet. So, yeah, so I'd like to see you guys tinker with this and get it away from, because we, the property is surrounded practically by homes, neighborhoods, and it would certainly, if this goes forward, would make a big difference. The farther away it is. That's why I'm coming from.
The one thing I will say is that in this area here, a substantial portion of this would be removed as part of that. So 300, and you're saying 300 feet from the property boundary to the panel?
And I'm saying it only for, I understand that there would be an issue with the northern piece.
Okay,
So I understand that, but Lisa Lane specifically, I'm looking at Lisa Lane, Keith Drive, let's see what else, it's Francis Barber, Beverly Ian, and Grant Sarah. So it's all of those streets to the east and the south.
So could you repeat those again, just so we're clear?
Yep, it is Grant Sarah Drive, Francis Barber, Beverly Ian, and Lisa Lane. And it's already far enough away from Keith Drive, so I'm not even going to mention that.
Okay. Great, thank you very much.
Thank you.
All right, thanks, Sylvia. Scott, you have anything? Not at all. Jack, you good? Thanks, Mr. Bennett. Okay, Mr. Dowling, I think you're up. You're fine sitting if you want.
No, I'd rather stay there, thanks. First one, sit down. Can you hear me?
Jim, just move that mic, just still here.
Hello? As you know, I represent a number of abutters. I ran into my parents last time for, I think, about 25 people, as well as the organization that is the Hopkinton Citizens for Responsible Community. I prepared a couple of things for you. I'm sorry I couldn't get to you for you, but some things have come up. But the first one, I was looking at the history of the various iterations of the solar ordinance, and I prepared a little memo on that and how it's changed and what I believe should be applicable right now. I have one copy, an original for the clerk with all of the exhibits printed out. The rest of them are copies so that you can have them to read yourself here. I will email them out to everybody just so you have copies of the exhibits. But the memo shows that back in it was 2014, that was the first time that the use code 486 was contained in the zoning ordinance, and it was the first time that it was referencing 486 as including solar energy development. Now, that first iteration was in effect from January of 2014 into July 18 of 2016. And the first one was very skeletal. It just basically had some setback requirements, etc. The second one, which was in effect from July 18 until July 16 until January just passed, January 9, 2019. That second one was much more detailed, had a lot of information in it, a lot of things that anyone who was applying for the permission to have a solar energy facility in the town of Hopkinton had to meet. Now, obviously, at all times, since the first mention of PSES, as they call it in the code, was entered, it has been a use that's been specifically prohibited in the residential 1 zone, the RFR 80 zone, and the neighborhood business zone. It's been allowed in the manufacturing and the business commercial zone, but there were caveats. And the caveats being that under that, once they got that information in with the requirements as of July of 2016, one of the requirements was that for anybody, as a permitted use, you have to go to development plan review. And the essential, real big difference in the latest iteration is that it's not just development plan review any longer, it's major land development. You have to go through the whole planning process. That was changed, as well as the caveats as to how much coverage for those lots that were changed, etc. That was changed. But the thing is, I went through all these things, and I was looking at the requirements, and the argument has been for a while. It was addressed last time again as to what rights does anybody have that's before you to vested rights, as they call them in the zoning ordinance statute. And when do those rights come to a person? What stage of the proceedings, etc. And I've provided a lot of information to you, supported by the cases that have been decided in Rhode Island, talking about vested rights, etc., the statutes, etc. But when I was going through all of this, I realized there's another angle to this whole thing, and this other angle prevents you from making any decision on this, prevents you from acting on this in any way whatsoever, because there are two sets of statutes that govern land development, whatever you want to call it. Land development in the state of Rhode Island. The first one was the Zoning Enabling Act of 1991, which is just followed by a couple of years the Comprehensive Planning Act. And then a year after the Zoning Act came in the Subdivision and Land Development Act of 1992. And in the statutes, they talk about what must be in any local ordinance, whether it be a zoning, whether it be a subdivision regulations, or land development regulations, etc. Tell me if I'm talking too fast. And because you don't have any authority to do anything other than that which is given to you by the state. It's a state police power, and they delegated that to the cities and towns to enforce on a town-by-town basis. So all those provisions of the two enabling acts, and if you look at your own ordinances regarding land development in town of Hopkinton, they use the word shall. Shall is in hundreds and hundreds of places in each of the acts. Similar, the same thing happens in the Hopkinton ordinances. And so shall means mandatory. I think it's in that one, I wrote a little blurb about it. The Supreme Court has mentioned it very many times and defined what the meaning of shall in a statute is, what it means. And essentially it says that the cases say it's mandatory. You must do this. It's not open to interpretation. Now, as to this specific instance here, we talked about where you get vested rights, and it's under the zoning ordinance, the zoning enabling. If you have submitted an application, that's the first test, an application. Second test is to submit it to the appropriate, it's got to be, obviously, application for land development. Then it's going to be to the appropriate reviewing agency for approval. And I've told you before that you folks aren't the approving agency. As the town solicitor mentioned last time, you're acting as a legislative body here. It's very different from what you do as a permitter. And the identity of the permitting agencies for any type of land development, those are all laid out in those enabling acts, and they're reflected in your own ordinance because they have to be mandatory. So there is no place in the enabling act that says that the town council can act as a permitting authority. It's not possible. Because those things are delegated to either the planner, first as a screener, the administrative officer who gives that, signs off on that quote, the certificate of completeness, which has to do with the substantial completed application. Or it's the planning board because they make decisions. They approve or disapprove of development plan review because of the various types of applications that could come before them. It's things like the minor subdivision, major subdivision, major and minor land developments, etc. And they make the decisions there. And the building official, if you've got a permitted use and it's just a single-family home or something that is accessory to that, an outbuilding or whatever, the building official makes those decisions, and they approve or disapprove. And if you say, well, I can't quite meet the zoning ordinance, and I'd like a little relief, and I'm going to seek either a variance from the terms of the ordinance, you look for a variance, and who does that go to? It goes to zoning board of review. They make the decision on that, whether to vary the terms of the ordinance. They also issue special use permits, which are they're conditionally approved uses as long as they don't injure the properties around them. But nowhere in your ordinances, nowhere in the state enabling acts will you ever see that the town is able to approve of specifics and specific ordinances. Specific projects. What you're doing is you're acting in legislative capacity. You're making the rules by which people who make applications conduct themselves. And I addressed this there, that in the Land Development Enabling Act, and it's also in your, and I lay out the particulars, it's also in your ordinances. It says that it's a section entitled Precedence of Approvals. And interestingly, they say, well, they give provisions for if you need town council approval, if you need town council planning, etc. And in the third section of that, it's Rhode Island General was section 45-23-61. If you look at that, the title of it is Precedence of Approvals. And the third section is section C. And it uses that mandatory language, the shall language, the stuff that you have to do from the state level and from the town level. It says that if you need an approval from the town council for the land change, and you also need a approval from the planning board, what you have to do as an applicant is you got to go to the planning board for the first stage of approval. And they give you a conditional approval. So under the ordinance that was in effect until January of 2019, the first level of the planning board's inquiry was the development plan review. So that's that first stage then. And so if you wanted to do something that required a zoning amendment and planning approval, obviously planning approval is hooked in because it's the development plan review that they conduct, you have to go to them first. You have to get a conditional approval of the project. And if you don't get that conditional approval, again, that shall language is in there, you can't go to the town council and ask for a zoning amendment. What you could do if it was denied at the level of the planning board, you could file an appeal if you were an applicant and say, I'm going to appeal that to the zoning board of review sitting as the planning board of appeals. And if you didn't like that, then you would go to the Superior Court and appeal the denial of the development plan review, etc. But until you've done those things and you have somebody saying that, yeah, this is approved, you can't go to the council. Because the council then can only, even if you had an approval, then you can go to the council and you get what's a conditional zoning. This is all in the statute, it's laid out. I think I printed out in full in the memo. That you have to go to them, get a conditional from the planning first, then you get a conditional zoning amendment, then you get planning approval. Now, that was before 2019. And 2019 changes a little bit because of the inquiry that the planning board will be conducting as that first stage is development, land development as a major land development project is the master plan approval. So for anything after January 22, 2019, the first step is go to the planning board seeking major land development approval through the master plan. And then you can do that. And if you don't get that, you can go up the line and you can appeal to the Board of Appeals for planning and go to the Superior Court. But all those things are conditions precedent to ever coming to the town council to ask for a zoning amendment change. They're mandatory. You haven't been following it. That doesn't mean it's right. What it does mean is that anything that you do and anything that you have done that is not in accordance with that, those actions, those decisions are void. As we call it in the trade, it's void ab initio. It's Latin for from the beginning. Doesn't matter when it's challenged. It's bad because it was not done in accordance with the law. Now, you couple all this with the fact that, let's see, who applied for what in this instance, as in all of the other instances that you've had before you over the last year. I've been coming to these hearings since last August. And every single one of the applicants whose property are located in a zone, 99% of them, I guess, were RFR 80, they've sought a change to both the comprehensive plan and to the zoning ordinance. That's what they've asked for. And where do they go for that? You, because you're the legislature here. You are the only ones who can grant that. But has anyone gone for development plan review? Has anybody gone for major land development approval through the master state? No. Everything that you've done is a no. Because of the fact that you're not following the law. And the law is what guides land development in Rhode Island. Property rights for land development, etc., our Supreme Court has said, as well as the United States Supreme Court has said, those are not some guaranteed constitutional rights. What they are is they guarantee, it's an indirect guarantee that people won't interfere with your rights, is that they guarantee that whatever the state is providing to you, that's a right that you can enforce. And the rights that you can enforce are not from common law. They've been overtaken and the field has been completely ruled, and is ruled, according to our Supreme Court at least, by the statutory setup of those two enabling acts. So what you've done here, and it always struck me as odd, I've never seen a situation where somebody says, well, I think I can get around that it doesn't, my proposed project does not accord with the zoning or with the comprehensive plan, so therefore I'll change the comprehensive plan. It just struck me as kind of funny. Never seen it before. It's an unusual approach. And I think the unusualness of it is because people don't bother to do it. Because if they did, they're going to have to go through a permitting authority. They're going to have to submit to the people that are in charge of the plan to begin with, that is the comprehensive plan, to say, hey, will you give us a recommendation that we that you change the comprehensive plan. One, the recommendation, that advice that we did get, there's two aspects that you get. The advice is one, two is the actual approval. People aren't going through these machinations because of the fact that if you go to the planning board who's prepared the comprehensive plan, it's kind of unlikely to say, oh yeah, we'll just change the comprehensive plan so then you can change the zoning ordinance so then you can do what you want. And tonight's a great illustration of the whole thing. I told you the very first time that I spoke to this board was that the comprehensive plan in the statute listed the intent of the legislature. And the intent of the legislature is that we want to get rid of, quote, reactive land development decision making. We don't want to say, oh, we'll look at everyone that comes up here and kind of knee-jerk reaction to it. Tonight was the quintessential demonstration of reactive planning, reactive approvals, etc. You get you're going into a place, these folks are going into a place that is completely surrounded for miles by RFR 80 zoned properties. It's all residential around them. And they're saying, well, we're going to plant this big, giant, thousands and thousands, I can't remember the number at this point, of solar energy collectors and establish a big, giant farm in the middle of your residentially zoned neighborhood. And a reaction is that, well, somebody says from this street, well, okay, we'll back off here. Oh, somebody's coming from this side, we'll back off here. You shouldn't be entertaining that because the zone is the zone. And what you're doing when you do that, you're bargaining away the integrity of of your ordinance. You're bargaining away what the state law says you have to do, what you have to consider on a case-by-case basis. That's why the legislature enacted all three of these enabling acts, the comp plan for the zoning ordinances and for the land development ordinances, because they wanted to have some uniformity, some consistency town to town. We're a small state, and before the enactment of those statutes beginning in the late 80s, it looked like you were going from country to country when you went from town to town in terms of the zoning ordinances, the planning regs, etc. Here, you've got to follow them. And so there really isn't a lot of variety between the towns, other than, you know, obviously each town can pick where you want this zone, what you think this should be happening in this area, but the bones of the whole procedure are set forth in state law, and you've adopted them. So by doing the procedure and entertaining this application as well as all of the other applications you've been looking at for the last year, you've been playing a game that has no sense legally, because you can't do it. The statute says this is what you're going to, this is how you handle it. These are the procedures you've got to go through. The ordinance says, and it mirrors it. Actually, I think I say the words are identical. That it says you have to do the same thing. Why it's been entertained like this, I don't know. Other than some people just think, oh, we're going to get money and we'll sell this off for that. But you can't do it in the first place. Now that's all I covered in that first one. The second one is just a letter, and I outlined some of my concerns because I was shocked when I read the transcript of the last hearing. I wasn't really keying in on the opinion that Mr. McAllister gave toward the end of the hearing, just because it was late and he was tired, etc. But when you read it in black and white, it was kind of shocking, because he gave a, quote, legal opinion, didn't tell you what he was basing it on, didn't tell you the facts which you viewed in kind of analyzing it, didn't tell you what laws that people were applicable other than that 45-24-44, which is in the Zoning Enabling Act. But it's only in that one place. And under the Zoning Enabling Act, the only people you can put application into would be the zoning board. You know, you can't just, it's not like applications are applications and nothing applies to anything that's been applied. There's hundreds, probably thousands of mentions of applications in your ordinances. I know it's about 150 different sections of your code of ordinances that talk about applications. Words are important. Legal. Words are important. When you say it's applicable to projects that are subject to this section, it means that section. It doesn't overrule something else. Particularly when you have to read all of these enabling acts together, it doesn't make any sense. I was shocked to just say, oh no, this is what it is. Well, if that were a quote expert in the courtroom, and they just said, this is my opinion, without anything else, they'll probably have their head torn off on cross-examination. Because we learn in law school, and I lay this out, anecdotally, you learn as a lawyer by what's called case method. It's a traditional method of instruction. You read these big giant books with all the cases, and you have to deduce what the rule of law that has been made in that, based upon the facts, how the judge, what laws they looked at, how the laws were applied to the examination of the facts, etc. That's what you do. And it's tedious at the beginning, but after a while, that's real life, you realize. Because, as I say, people don't come in and, when they're asking for a legal opinion, and say, tell me about the law of perpetuities, or could you recite Article 9 of the Uniform Commercial Code? They don't know that. They come in and they say, this is what happened. I feel uneasy. This is what happened. I got this problem here. Can you help me? And the lawyer listens to the facts, tries to get the whole story out, and then looks at the law, researches if necessary, applies the law to the facts so they can come to a reasonable, a sound legal decision based on something other than this is what it is, I think. Because that's a personal opinion. That's a personal, that's not a legal opinion. And all we have here is, right now, this record stands that you've got volumes and volumes of information regarding the application of various statutes to the issue of the zoning, to the issue of the vested rights that accrue to any applicant, what it means to be an applicant, who you have to apply to, etc., and all the case law and all the statutes, and therefore you can't do this. Versus on one hand, then you say, oh no, it isn't. Without any, it's not capable of being reviewed by anybody because you have no idea what was being considered. And it is basically not something you can rely on. I don't know why the solicitor didn't tell you a year and a half ago that about the existence of section 45-23-61, which says mandatorily, if somebody asks for those two types of relief, you're going to go to the planning board first. But that's not my business. All I know is it didn't happen. Now step back and look at the whole picture. Has anyone given a quote application for development to the appropriate agency in this town? I don't believe so. Other than those projects, and they're all small, that it was allowed in a certain area. It's a permitted use in a certain area. So you can do that. You can go if you want to, oh, I'd like to have this. I'll go and I'll seek development plan review before the planning board. They never had to come before you. But those projects which have to come and ask for a, first the comp plan change and the zoning plan change, none of them have gone to the appropriate authority. And your authority is limited only to the legislative act of saying, okay, we'll allow a zone change. You don't act on individual applications. That would be improper, and it's certainly not authorized. So I think you're wasting your time. I think you've been wasting the time of developers. I think you've been wasting the time of the many, many people, the citizens, who the zoning, enabling act, the land development act, all of your ordinances, they're designed to protect. Because the comp plan says that we want to avoid any reactive decisions because we want to have things that we can rely on. And that's why you don't see other cities and towns doing this. Well, we'll adopt a comprehensive plan on, in this case, February 8th of 2018, and then 10 days later, act on an application to amend it because somebody wants to put a solar farm in their residential neighborhood. You don't see that anyplace else. And unfortunately, the Sharks knew that there was blood in the water, and they came recent action because they realized that you weren't in accordance with state law. And they realized that they could get somewhere by waiving some dollars. And that's not right. So I would ask that you, as I asked in one of my, they dismiss this, you deny it, and you're not taking any more. Because we can't. And recall that this was, as I say, there's no application filed on this with anyone. A letter was sent, 2 letters actually, for the 3 properties involved. Letter was sent, and who did it go to? Went to the town council, the rest of the town council. I provided copies of all this stuff to you before, like at the last time. The rest of the town council submitted to the town clerk. Town clerk says it's received on October 22. And then, as normally, you're asking for a change. That's all they asked for. They didn't ask for anything else. They asked for a change to the comp plan and a change to the zoning ordinance. They didn't talk anything about anything because they couldn't. They couldn't ask them about anything. They could not ask the commission to do these things. They say, "Can you change the ordinance so we can do this?" Additionally, as an aside, and we all know now, although I argued it months and months ago, and I told you why, there is no such thing as a commercial special zone. That was referring to things. A commercial special zone referred to properties that existed with special limitations as of the adoption of the zoning ordinance in the town of Hopkinton on, I think it was sometime in December of 1994. That's when everybody did it. That was the end date was the 31st of December. We had to have a consistent zoning ordinance in accordance with the Neighborhood Act. So you, all this stuff doesn't make any sense, what you've been doing. And, you don't know. You're late people. Somebody comes in, I guess you're going to be courteous, you're going to listen to them. But putting in a quote, letter, which requests changes in the comp plan and the zoning ordinance, does not equate with an application for development. They're not asking for development. They're asking to change so that they could ask for development. So that they could, once they became a permitted use, then they could ask for the permission to do things. But until that point in time, you can't ask the planning board, the zoning board, all these, the building official, etc., to allow you to do anything. Because your use that you're now proposing is not allowed. So until they get to that point, and they say, okay, you guys, you folks approve the changes, which we void anyways, but if you did do that, then they would be in position to file an application. I get into the memo there, what the application is. It's defined in the zoning ordinance. It tells you what it is. Nothing is ever done with this. So I leave it with that, and I'm not going to belabor the point. It's there. I will send out copies to everyone, so everyone's got one via email tomorrow, and all of the exhibits that and what with the first memo. What can I say?
Yeah, Jim, so there was only 3 copies, so you gotta send them.
No, I'm going to get to everyone. Yeah, I just my computer died. I mean, in the middle of bringing today. So.
Okay, thank you. Kevin, we want to address just some of the questions that Mr. Dollar raised legally and what our role is, and just, you know, not writing legal history again, but, you know, just be as succinct as you can and just address some of these concerns so the council understands it, please.
Yes, I'm glad to. I'm not going to give a point-by-point rebuttal. For example, the letter he just submitted I have not seen before. I will say that I fundamentally disagree with his analysis of the applicable laws here. It's simply not nearly as complicated and interwoven as he says. I recall appearing before a Superior Court judge many years ago who expressed that his philosophy is that the longer it takes someone to explain a position is inversely proportional to its validity. And that thought came to my mind tonight and at the last hearing. But I want to explain very simply what my opinion is based on. First of all, the only legal question before the council, which is before you tonight and through these hearings, is whether or not the application for the zone change and the application for the change to the future land use map attached to the comprehensive plan would be consistent with the comprehensive plan. That's it. So when you get to this, Mr. Douglas has cast his argument as a sort of a scholarly discussion of vested rights. Well, what he's really getting at, I think, and what the real issue is whether or not the version of the PSDS ordinance that was enacted in January of 2019 applies to this proceeding if you grant a zone change. So it's a hypothetical question that you don't even need to look at. But if you do look at it, and I'm suggesting to you that that is not relevant to whether or not these applications before you are consistent with the comprehensive plan. But even if you do consider that as a factor in your thinking of whether it's consistent with the comprehensive plan, the fact is that this applicant's request for a zone change preceded by a long time the enactment in January of 2019. And I said last time, and I say it again, that when they filed their application for a zone change, they had already done their homework, investigation, discussions with the landowners, engineering, all kinds of consultants. They spent a ton of money relying on the PSDS ordinance that was on the books. Then they decided they wanted to go forward. They decided to file a change for the zone change and the change to the future land use map, relying on the PSDS ordinance that's on the books. You can't change the rules after someone files an application. I never said, nor would I ever say, that they had a vested right to a zone change. That's preposterous. Mr. Donnelly's correct in saying with this current RFR 80 zoning, they cannot do the solar thing. That's why they have to go first. And that's why I read almost verbatim Rhode Island General Laws 45-2444, which covers this. You can't change the rules. It's just clearly not allowed. That's not just my opinion. I'm very certain I'm correct about this. So this council should focus on whether or not these applications before it are consistent with the comprehensive plan or not. That's the only valid legal question before you. If you're interested in which ordinance applies, that's a question of does the ordinance that was passed, the PSES ordinance that was passed in January, have retroactive effect? My opinion is unqualified, and it's no, it doesn't. Because they had already a right to pursue their development plan, which requires as job one to get the zone changes and the map change. They relied on that, they put it in the works. If you look at the statute governing zone change applications, it makes it very clear that it's filed with the town clerk and it's then submitted to the planning board for an advisory opinion, not a determination on preliminary plan of view or any type of regulatory approval. That's absurd. You don't mix in 4523 statutes with 4524 statutes which cover zoning. You can't possibly do that. It makes no sense at all, and none of the case law supports that. So, the final point I want to make about this is not a debate between me, or it should not be a debate between me and Mr. Donnelly. I sit here as an advisor to the council. I'm not an adversary to Mr. Donnelly and his clients. I'm not an adversary to Mr. Craven and his clients. I'm here to give the council my best advice as I can. And I'm telling you, without any qualification, I'm very confident in the opinion I'm giving you. The real question before you is it consistent with the comprehensive plan? That's it. And if you want to think about whether the PSES amendment or ordinance that was passed in January of 19 has a retroactive effect to apply to these applicants, the answer is no. It's clear as a bell. It's really not that hard. And I didn't take an hour to explain my position and submit reams of paper. I'm happy to do that. The last thing I want to say is this argument, among many other, is the subject of a pending lawsuit in the Superior Court from the Maxim Hill project. There were two lawsuits filed by Mr. Donnelly on behalf of clients related to the Maxim Hill project. They're both pending in Superior Court. I'm the legal counsel defending the town in those cases. Mr. Donnelly is plaintiff's counsel in those cases. Those questions are going to be decided by the Superior Court, and we'll see who's right and who's wrong. But I'm doing my best to give you good advice tonight. I'm doing my best to give a strong defense to the town council in those pending lawsuits, and I caution the council to be very careful about statements or opinions that you may have about vested rights or the way Mr. Donnelly framed it, because these are issues that are going to be decided by the Superior Court. And I'm very reluctant to try a case or part of a case for these applicants which are already before the Superior Court. So it's not at all, in my opinion, what Mr. Donnelly is saying. I'm sorry he was shocked by my opinions, but I stand by them. I reiterate that when the time comes, we'll have our debate before the court, and then we'll see who's right.
Thanks, Kevin, appreciate it.
If you're totally convinced that
Mr. Donnelly, what I'm going to...
I just want to make one comment. I'm going to provide one piece of
Hold on, folks.
If you're so convinced that he is giving you a great opinion, I'm going to just give you a copy of the hearing that you had on the amendment, December 17 of 2018, when he was, quote, advising you as to the appropriateness of the matters being considered. At that point in time, I'll just give you. At that point in time, he gave an opinion. It was this is for yours. It's the only one. He gave an opinion because people were asking and talking about what kind of penalties you could have. I know that from the transcript or the minutes, it says that Ms. Thompson said, well, you can get an injunction or something if somebody does that. And your town solicitor said, oh no, it's limited at $500. It's got to do with a felony and a misdemeanor and all of this malarkey. To which the council president echoed, yeah, it's a felony. Right there with you is, see, just like I did, I looked at the statute, the enabling statute. If he has such a great opinion, all it takes is a minute. What can you do in a zoning ordinance? Look up violations in the enabling statute. That's where it says you can have
violation topping out at 500. And also attached to that one is also your own ordinance that says this is the maximum fine you can give. That's where it comes from. It doesn't have anything to do with felony, misdemeanor, and all this stuff. These ex post facto laws deal with criminal penal statutes or interference with an existing contract. That's it. This stuff about ex post facto, that's mumbo jumbo.
Okay. Yeah, thank you, Mr. Dunn. Sylvia Thompson has a few items she wants to discuss with the applicant's representatives.
Yeah, this project, if it should go forward, I have a number of issues. And by the way, what I'm about to talk about, I haven't talked to the developer, I haven't talked to the council, I haven't talked to the world. So this is something that I've been thinking about for some time, and I wrote it up just last night. And it has to do with, well, I'll just read it. Number one, if this project does move forward and you get all your approvals, when a building permit is pulled, I'm requesting that the applicant, the owner, will pay the town 50% of the estimated building permit fee. And I'm hoping I could put in that it would be non-refundable in case anything goes sideways. But by the time you pull a permit, if you did, then I would assume you've got all your approvals, obviously. The remaining fee will be paid when the project is completed. Normally in town, when you pull a building permit, you pay a small fee to begin with, and at the end of it, you pay a larger amount when you've completed your project. So the reason I did that was just to try to help the town out a little bit sooner than later. The applicant, number two, the applicant owner will pay, in lieu of taxes, will pay $250,000 payable in the first year of operation, and $250,000 payment in lieu of taxes in the second year of operation, and thereafter $20,000 for an additional 23 years. So then that's $20,000 per year in payment in lieu of taxes for 25 years. The third one is the applicant owner will donate $5,000 each year for the life of the project to the Hopkinton Land Trust. And when I say life of the project, it means the life of the current project and any continued use of the property for solar. As long as solar is in the project, the land trust will continue to receive $5,000 per year. The last one, no, I'm sorry, it's not the last one. Number four, the applicant owner will purchase the development rights to a piece of property. Well, I'll read what it says and I'll explain. The development rights to plat 14, lot 59, which is approximately 60 acres of forest, and it happens to be in the farm forestry program at this time. The parcel's development rights will be donated to the town. And I had put, and I was thinking, well, when does that get donated to the town? And I had put down that within 3 months of receiving a building permit fee from the town of Hopkinton. I will refer back to the applicants, and that might be not a good time, so I'm not sure about that one. I'll leave that one open, but I'd like to see that happen. The last one is what I've already mentioned, is that we would like to see the abutter property lines in the area of Lisa Lane, Francis Barber, Beverly, and Grand Sierra Drive to be 300 feet from the panels, from the property line of the abutters. And that's it. Oh, the other one that I was going to explain about the development rights that you guys can purchase this property. This particular property has been mentioned a number of times with the two of the past proposals that were denied. And what's special about this particular property is just that from a previous forester that went in and looked at the property, he had stated that the forest, and it is mostly forested, has got one of the oldest forests and trees in Rhode Island. So it is a healthy forest. And I know that this particular project, at the moment, you're only looking at around 6,700 trees to cut down, not tens of thousands of trees. But this project is, this other piece of property is a beautiful piece, it's pristine. That's it. And I did delete a couple of proposals and I changed it and just tonight. So what I do have is a marked up version, which I will give to the town clerk. Do you need a copy of the marked up version?
That might be helpful, yeah. I wasn't taking notes.
Okay.
Just a query, is this part of the zoning ordinance?
This has nothing to do with the I'm not sure what the question is, however, this has to do with just trying to make this more palatable to the
No,
town.
I'm just asking because there's this little bit of instruction who are acting as a legislature to amend the zoning ordinance. Is this part of, it's
Kevin, you want to answer that question before Mr. Donnelly? Just block Willard top. Jim, if you have a question, just address the board and we'll answer.
Is it part of the zoning ordinance, these proposals?
Kevin?
I would say that Councilwoman Thompson has the right to express her views. I would caution her against bringing herself into a cross-examination situation from someone sitting in the audience. I mean, I don't think this is appropriate at all.
So that's it, Jim.
Fine.
Thanks. So, Mr. Craven, you might have, and obviously probably have to digest all that stuff.
Yes.
Okay.
I can talk to Mark. I don't think my client wants me to spend his money right now.
Okay. Do you have any comments on your end?
I think that there was some council president yourself referred to the potential of other people wishing to testify. It might be helpful to do that now before I make any remarks.
Well, I guess, I thought you had one property evaluation person, but.
That person's not available, unfortunately.
All right, so-
Mr. Craven, I would ask the council and the council president, I'd like to have the opinion of the tax assessor of the town of Hopkinton. I'd like to ask the tax assessor of the town of Hopkinton, who's an employee of the town, to answer the question. It seems to be a question in this community about the impact of property value of flooding homeowners with solar arrays, specifically the people impacted by these projects. So I respectfully ask that the tax assessor answer the question, will be an increase in the property value of the abutting and neighbors of these proposals? I don't think that's been asked. I respectfully ask the tax assessor to answer that question. And of course, we do know on another waiver, maybe in political science, we have some understanding of the word, that there is a difference between the word shall and may. And I'd like to know how relevant you think on the issue of dealing with these ordinances and the rights of property owners and also your feeling on that. Also, you agree that production of electricity is a manufacturing function. What I'm getting at is, we think of a rural farming residential area, we don't consider manufacturing an appropriate use in that area. So I do ask the production of electricity correctly, legally, be labeled manufacturing. And also, what I find interesting in reading is Mr. Donnelly, that we can only amend the comprehensive plan 2 times during the year, and every time we approve, or the council is trying to approve any of these any of these solar projects, that are we amending the comp plan that we run out of the time to do that in the calendar year? I think that's a question that enters my mind, and I'd like to have an answer to for that. And also, when you look at legal decisions, they usually refer to certain court cases and such a case. And I know there has been some reference to court cases in our readings, but is everything in order as far as approving this? And also the powers of the town council, the legislative, we're not the zoning board, we're not the planning board or any other board. The background, the legislative processes, and the tax benefits, the aesthetics, the neighborhood area, the feeling of their butters, as well as people throughout the town. And I would state, Mr. President, that the thing that really concerns me about big solar is it's permeated throughout the town. And if we grant one, and we turn somebody else down, two big winners and losers, and the whole town is impacted. All the way from the northern part of Hopkinton down to the southern part. I heard people talking about the situation over in the Birdsville area with the solar that's going in there. So everybody's talking about the town. I heard about it endlessly, and people, Francis Barber Drive and all these associated streets, I heard from them all the time by email, and that sentiment is pretty well known to this council. Thank you.
Okay, so I know, Bob, a lot of what Scott mentioned perhaps could be answered by our own solicitor, Kevin. So, to the extent you want to comment on any of these questions, and the rest of it we can get with Kevin and the tax assessor.
Well, with reference to the tax assessor, let me suggest, I do not know your tax assessor. I don't know whether or not he or she has any appraisal skills or any licenses.
She wasn't appraisal.
She wasn't appraisal. Then she may be capable, but I'm going to guess that you folks also have vision appraisal that does your every third year reevaluation. They might be helpful to you as well. And I'm sure that they would do it across the town. But with reference to the debate on the law, Councilman Hurst, I leave that to your solicitor. He is the person that you should be listening to. I'm a little bit even more brief when I would speak on this issue. The statutory scheme that is laid out by the General Assembly to have an opportunity to change the zone, which means to create a different zone or a different use under an existing zone, is left to the members of the council. And the statutory scheme to get there is the planning commission or planning board, depending on what you call it here, is either up or down as a recommendation to you. And the last thing is that whatever is done has to be consistent with the comprehensive plan. Or it needs to be, the comprehensive plan needs to be changed. So that's how it works. Everything else that Mr. Downey was referring to is beyond my experience, and I've done a lot of this kind of work, including actually passing some of the laws that that were involved with this statutory scheme that we talked about today, as a member of the General Assembly. And lastly, with reference to the number of times that you can change your comprehensive plan in a given year, statewide planning is a state agency that has jurisdiction over some of those issues. There's no one that's keeping a checklist up there. I would tell you the frequency by which you change your comprehensive plan is more likely to be offensive to whatever it is that you may be trying to do by virtue of the fact that you're doing it willy-nilly or you're doing it all the time. In other words, every time you run into a little roadblock, you change the comprehensive plan and you change the zoning scheme. I don't believe Hopkinton has ever been that type of municipality. I hope I answered the question.
I just would respond to that, saying that the councilman sitting here, the whole town is talking about solar. I don't think there's a personal town that has solar. We have many projects, I agree with number 30 of them, correct, the number of solar proposals we have in town. There's more going to come down the pipe, and the question of consistency, the question of what the neighbors think, the town itself, financial issues, and town council has a legislative authority. We also should use that to benefit of the town in a thoughtful, logical way.
Last year when I was researching things in relation to Woodville Walton Road project, I did contact planning, state planning, and about the comprehensive plan and how many times you can change it in a year, and it's three times a year. That's, and I think last year we did two, possibly two. So it starts on January. It starts all over again on January. So we haven't done anything this year.
Thank you. James, for your input, Council Davis.
Okay, thanks, John.
Again, if I can comment, Councilwoman Davis, that is the statewide planning commission. They have no absolute jurisdiction over this issue.
I thought we had, well, I thought actually when we change the comprehensive plan, we should be submitting that change to the state so that they know. And they're keeping track.
Yes, they do.
So it should be, if they said it was three, then it's three. If we don't submit it, they'll never know.
Correct. And I think that they monitor the fact that the town hasn't lost its way. There's an approval process that happens every 10 years with comprehensive plans where you submit to the state and they have a review by their folks up there.
And that happened in February.
And they want to make sure that you haven't lost your way. And that's the reason why there's a suggestion to all municipalities that they not do it frequently, that they do it only when needed. And if somebody told you it's 3 times, it's not at all. I can assure you of that.
I'll provide you with a copy of the statute.
Jim,
It says 4 times. I've provided to you.
You're out of line.
I may be
You're
out
out
of
of
line,
line.
but
You're out of- you're out of
I've
line.
already given it to you. I'll give it to you again.
Jim, stop it.
I want to
I'm going to comment. The council, I think, I'm trying to think, either Kevin or the clerk, one of us, reached out to statewide planning. They rendered their decision on past applications that were approved. They agreed with the town on their approval of the change in the zoning and the map plan change. There was some minor, I guess, reporting requirements, not reporting, but more where the maps are detailed and the notice requirements. They had some minor changes on notice requirements, but that was it. But any prior project, and we've got proof of that, any prior project was okay by statewide planning. We heard from them directly, and we've got proof of that. I've got proof of it. The clerk's got proof, and so does the solicitor. And we'll get that to the council.
So if I could make a few brief comments
Sure.
of where I think you find yourself at in reference to these applications. I believe I agree with your solicitor and Mr. Donovan that right now you're at a point in time where you're considering an amendment to the comprehensive future land use map and an amendment to the zoning ordinance to allow for the comp map for low density residential to commercial and your zoning map, and that RF80 would be commercial for solar purposes only. And that use would be abandoned, and the commercial aspect of it would be abandoned upon vacating or abandoning the use itself. These projects that we've discussed with you have roughly a 25-year lifespan. So at the end of 25 years, if it's not being used for solar, it would revert back to the use that it previously had, because it couldn't be used for anything else other than solar. Nothing.
But it won't go back to, it won't go back to that.
It can't, but it can't be used for anything else other than
Then it won't be good.
Yes, you can. You can have it reverse out.
It's not automatic, that's the point.
It isn't automatic, but the law objects and it abhors the fact that a piece of property wouldn't be able to be used for anything. So if it can't be used for that which it's been changed to, or would be changed to, in 25 years when the lease is up or when the existence of solar of that nature, I think I mentioned this to folks when we first were here. I remember with some clarity as a political science major with Councilman Hurst at URI, that you always could tell the engineering majors because they had that big giant like holster with a TI computer in it. And it was like a $250 computer. That same function is now on as an app on my iPhone. So the technology has changed radically. And I fully expect that technology can change radically as it relates to what solar will be as far as a capturing of energy in 25 years. I expect it to be smaller and maybe even, like in some respects, in the last 10 years with cell towers. You don't have the big tower anymore, you have something that if you put a flag on it, looks like a flag.
But it will still be zoned commercial, but not go back to residential, that's the problem.
I think for purposes of clarity, as a commercial piece of property, it can't be used for any other commercial purpose other than solar.
But it cannot go back to residential, that's my point. I think we're talking about two different things.
Well, as I said,
My emphasis is that once you change the zoning from residential, it cannot go back to that automatically. That's my point.
not automatic. The council would have to act. Yes, you're correct. But it won't be a building in sometime in the future. Not under this proposal. It can't be.
You
It's
don't
limited.
apply it, you don't apply it. If you don't apply it, it becomes commercial property, you can put whatever commercial on it you want.
Kevin, you want to... No, it's not correct, John, so I want to correct this. It is not correct. Kevin, we talked about this issue in prior applications, and I know that, I think before we made it, I don't know, you want to talk about it, because I think we have a remedy of reverting it back to RFRE. It doesn't automatically do that, but there's a way to do that, and to make it a part of the record to do that, so that nothing else happens other than what was intended.
And that's the intention of the applicant.
Correct. So Kevin, do you want to just quickly wait?
Yes.
This did come up on several applications before.
Yes, this is covered in my December 5th, 2018 compendium of legal opinions that I gave to the current council. It's number 5. Just to boil it down, the best way to look at this is it doesn't revert back automatically, as Councilwoman Davis has said. But if it's approved, and what's been done in past instances where solar projects have been approved, every one of them, in fact, in this town, one of the conditions set forth by the council is that nothing commercial can be done on that property forevermore, other than this solar type project. And then, at the end of the life, Attorney Craven is correct. Another condition, for example, is the decommissioning process. So once it's taken down and decommissioned and all the things are pulled out of the ground and taken away, Councilwoman Davis is correct in that on the books it still says commercial, but nothing can be done on it commercial other than another solar thing. So the council, the best thing to happen after that, if the intention of this council would be to revert back to residential, to make that clear that that's what they want, but it will be up to the council sitting 25 years from now to actually respond to an application to put it back to RFRE, and then it would be airtight and that would happen. But the important thing is if this is approved, and what Mr. Craven, as I understand him, is asking for is a condition of approval that nothing commercial can be done if the zone change is changed to allow solar other than the solar. No other commercial use can be used on that property. So we kind of all right corrects on that. But this is, you know, I'm not coming up with this off the hook. I got about a 2-page explanation of this in my December 5th, 2018 memo, which you all have.
Thanks.
And at some point in time in the future, and this is one of, I'd like to say this to Councilwoman Davis, because there's a built-in reason why the owner of the property in 25 years would want to do that which everybody in this room would like them to do in 25 years. And turn it back into a farm, if that is appropriate, or turn it into a subdivision, which would be, both uses could be done today. If that person, if solar is not commercially viable in 25 years from today, then you own the piece of property, you're paying the taxes, and you can't do anything with it, you want to do something that you could do by reverting it back to a residential use for farming or for a subdivision. There'd be a built-in economic reason why you want to do it.
Okay, that's what's good. We're all set?
A couple of other things. I'd like to just say to the council and to the members of this audience, I understand why this is something that's difficult to deal with, because it's change, it's uncertain. But there are certain certainties to what could otherwise happen with either the TEF or the Gordon property. If farming is no longer something that they can either afford or have the ability at their ages to do, then by right, this piece of property can be turned into a subdivision. And with reference to those, that property, it would house about 45 houses, roughly. Might be a little bit more depending on how it's laid out. That lays out to be about, if there are a couple of kids in every house, on average.
Folks, he's allowed to speak. Everyone will have a chance to speak. Keep it down, please. Thank you.
I'm looking at the economic impact of what a subdivision is. Okay, I understand. Now, this project will have no such impact. It will actually produce money. It will produce money over the next 25 years. It will fill the deficits that, in some instances, the budget has just simply become more difficult because of escalated clauses in contracts. In some instances, because the General Assembly or the Department of Education has cut back regional school budget bonuses that you should be getting and are not getting. And in some instances, it's because simply the economy hasn't been as good or might not be as good in the future as you hope. But this will be no lights, no change to the underground water. Right? It'll be silent. It won't have traffic. It will be something that produces income without being known, other than those suggestions that have been made about setting it back even further, so that it can be seen that the vista of this beautiful community won't be upset. Those things that we have made every attempt to accommodate, and we'll continue to make additional attempts to accommodate after I have an opportunity to read Councilwoman Thompson's request, so that it's not something that's going to change a neighborhood as much as a subdivision will change a neighborhood. And if a person owns the property and they have the right to use it, then they have the right to use it. Where we believe, although it is an economically viable use to build a subdivision, we believe this is a more economically viable use of that property. That's the reason why we've asked for zone change and change to a comprehensive. I'll be happy to answer any more questions, but thank you very much for your attention to this matter. I know it's very difficult.
The only thing that concerns me is being the history and political jump here, I guess. The General Assembly has a bill to have, I believe, 4 or 5 regional school districts. I don't go anywhere. But within 20 years, 25 years, and I'm in my middle 60s, it's conceivable that the way we address education in Rhode Island is completely different, and it might not resort to property taxes. So the assumption is that maybe if houses were to be built, that we wouldn't have property taxes, but in the long term, depending upon where the state is going to go, the state has the power to control education, which a lot of school districts are reminded of. That could change within 20 or 30 years of life of these solar panels. Thank you.
Councilman Hurst, I will tell you that a factually different but similar experiment with the General Assembly as it relates to the 39 municipalities is currently going on right now. That's called the car tax. The car tax is full funding by the General Assembly so that it takes the municipality out of having to pay for or to ask folks, citizens, to pay a car tax, and the General Assembly pays it anyways, is looking somewhere around $220 to $230 million as soon as the entire pill is swallowed. We're in year 3 now, going into year 4. And the car tax doesn't compare anywhere near the cost of educating children. So if it did happen, it would be a huge lift for the General Assembly to basically change the way of our relationships between state government and municipal government.
Thanks, Mr. Chairman. Thanks, Scott. Okay, we're going to start with the residents. The last time, I think I missed maybe 1 or 2 from the prior hearing that wished to speak. Whoever that was, please feel free to come to the podium. Again, it'd be helpful if I know how many folks want to speak so I can gauge the time. If it's not too much trouble, if you want to get in, it'd be great to start a line. It'd be very helpful for me. Just so I can get an idea on the time. I want to break at 9 for the stenographer Meredith. So I'm trying to be a little aware of her needs. I haven't done that in the past, and I'm sorry. Anyway, is there anyone, I guess, that emailed me, I can't remember who, that wanted to speak that I missed at the last hearing? Okay, all right, I guess that person is not here. Okay, you're up, man. Thank you.
Good evening again.
I can't hear you.
No, sorry. Get a little closer. Good evening. My name is Colleen Steffen. I'm in Butter. What's your name again? Colleen Steffen. And I'm a butter on the Scoundrel project. And my house is at 22 Lisa Lane, one of the closest properties, next to 25 Francis Walker. And this is my 3rd meeting. I don't envy any of you sitting up there today. But I did want to come back and speak today to posit my thinking. So I moved to Hopkinton 1 year ago, and I actually was attracted to the area because I fell in love with this open space, very forested, very lovely area. And at the time, I didn't know that there was going to be solar development in the discussion in the works. So I can honestly say that would definitely have changed my opinion of moving to this area. You know, I was looking down closer to Charlestown, but I really fell in love with this corner lot, this land. And it's really weird. I can't, it's personal. It's personal feeling that how much I like this area. But I can tell you from where I see it and from what my view is, even if you set back the solar panels from my house, that really gives me a wider view of the solar panels. So I'm not satisfied with moving panels back 100 feet, 200 feet. Just, in my opinion, it doesn't belong in this area. And seeing being,
I think we're all here today because we just, financially, we run out of the road. That's why we make changes. And I think looking 25 years into the future, we don't know what that's going to, where that will be, education-wise. I can tell you, I think that there might be, other things that can be done to supplement financial revenue for the town without sacrificing the land that is so important to this area. We don't have the luxury of giving away land like California or Nevada or New Mexico, where they have giant spans of acres and miles of land to just carve away. I guess some of the lovely area, but in this, in the way that this is posted, the north, south, and west sides are completely going to be shuttered from forested, the forested area. These could be very important corridors. I don't obviously know that all the breeds are in this area, but it inhibits this entire corridor. There's a tiny little separation between the south and west side. But I can only imagine how that will impact any of the migratory patterns of any of the wild animals, songbirds, the things that I really love about the animals that live close to my home. So, fences, they would restrict all of that easy access. And it would actually diminish, I think, the beauty of the area and the things that I think are the most important. I'm really talking from a simple view of the law, finances. Those are very important things to consider. But the longevity of protecting this land and the stewards of this land is so important. I just like you to consider that when you're making a decision. Thank you.
Thank you, Colin.
I have copies of the letter from Corey's.
From what? Yeah.
From the Corey's that live at 38 Lisa Lane, who couldn't be here tonight.
Okay.
They're
Yeah,
actually
give it to
on-
Lisa.
He's actually on active duty.
Okay.
So, just thank you. So that's a letter from them. They actually were one of the truly unfortunate ones that had their property in escrow. They actually were in escrow. And the agent and the seller didn't tell them about any of this because obviously it was a detraction. Okay, they wouldn't have purchased the home had they known. But here they are, okay? So there's a couple of things that I'd like to talk to you here. First of which is the fact that Mr. McAllister talked about the fact that your only job is to either approve whether or not this is in keeping with the comp plan and approve the zone change or not. But we've sat through meetings where you guys have been talking about things like the placement of solar panels, whether or not there's going to be mountain laurel planted there. So, honestly, there's a whole lot more being discussed than whether or not this is, correct and in keeping with the comp plan. So I'm not really clear about what Mr. McAllister was talking about with regards to that limitation that you have. The other thing that I heard was the idea about reversion. Well, the property on Palmer Circle was zoned, changed to commercial, special for a hotel. They now have solar panels on them. So obviously commercial special does not get abandoned and or changed back to residential automatically. It actually tends to go commercial again. So that's a big deal. That's a big deal once you get a piece of property commercial. We've come to you with our emotional pleas, our safety concerns. We've detailed the environmental impacts. We've talked about the financial concerns we have about our property values. We've spent our money and our time defending our neighborhoods from this. But all of this could have been avoided because the developer had no right to proceed. I'm going to read you a direct excerpt from November 7th Planning Board meeting. Mr. Epps, Mr. Craven, and Mr. Benavides were in this meeting, and this is Mr. Epps' own words, and it's starting at minute 15 and 5 seconds. This is exactly what he said. It is a concept plan on what the property can actually hold as a development for a solar facility. It does not, however, meet the requirements of an ordinance that the town is in the process of looking at because we don't know what that ordinance is going to be at this particular time. But it would be our goal, all of our goals, to meet the requirements of the ordinance as the ordinance is going to be stated. End at 15 and 32 seconds. Mr. Epps, Mr. Craven, and Mr. Benavides were absolutely 100% aware that they were going to be subject to the new ordinance. I have no idea what we're doing here with this. These hearings have been conducted under less restrictive ordinances. I don't know why this was not brought forward. Quite frankly, I don't know why Mr. Craven didn't bring it forward. Mr. Epps made it crystal clear that they all knew that they were subject to that new ordinance. So who's on first? Can somebody please explain that? Thank you.
Thank you.
I'm Richard Noel from Lisa Lane. I tried to do this here until this morning. This guy thought I had a lot of things to say. I think the things you've all read, so I'm going to say this another way. I think Mr. Craven's closing remarks speak directly to this. We all understand that there are people, many people, who are going to be damaged by this. But the justification is financial and the town benefits. So we're willing to have these people suffer whatever inconvenience or damage to their personal property because the town will benefit. So here's my question. If we'll do this for $100,000, what if any of these developers came to you and said, we'll make a deal, we'll double it, we'll triple it, we'll solve your problems, we'll pay half your budget, but you got to burn down 3 houses and drive 3 families out into the prairie. The question is, and this is a very difficult thing, because most people have a real hard time letting go of their preconceived answers. I'd like you to start seriously from first principles and think about the idea that we're willing to sacrifice some citizens for the general benefit of others. If we could solve the problem for everybody and never have an increase in taxes, but you had to pick 3 of these families right now and say, walk to the edge of Hopkinton and you're going to burn your house down. Which 3 people would you pick?
Thank you.
Jane.
Hey, Jane.
I'm on Scott Hill Road. I'm not Lisa Lane. I'm not Princess Barber. So when people start picking out which properties are going to get special treatment, that worries me. 45 houses. He wants to put 2 kids in a house. There are 6 houses that the original, what I call the original new section, that we're new. I've only been here 40 years. The new section of Hope Valley at that point, there were 6 houses. There have never been more than 5 children in those 6 houses at any given time. Last year, before the new family moved in, there were 2 out of 6 houses. 25 years from now, I'm not going to be there. I'm sorry if I have to talk about me. But you're talking about it as, well, 25 years from now, it's going to be okay. It's not going to be okay for me. I'd like to spend the rest of my time happy. If I sell my house, and it probably will be less, okay, good if kids there, is that so bad? But that's how some of you are thinking. There's going to be more kids. Well, a lot of these people are there, and their kids are grown. So they're not having kids. But if they sell their house, because we're going to try to sell it before it gets too bad, before somebody can look at 60,000 panels on, I forgot what map it is, 70,000 panels, we might have to do that. I don't want to have to do that. And Councilwoman Thompson, I have to point out that I loved your husband when he said that what kind of water did they try to do? He says it's not the harm of water. Well, we don't know that because the test he did was certainly, if not anything, inconclusive, because he didn't use rainwater, they used, sound like distilled water, which is going to react with metal. So I have to commend your husband for picking that out. And that also bothers me. I don't know how much information you get that we don't see. We're answering questions, we're trying to give you information, and we don't even have your information. Isn't that kind of scary that only 5 of you know what's going on? Thank you.
Thanks, Jane.
Hi, my name is Christian Ginos. My husband and I, with our adopted special needs daughter, lives on Dyke Road. Janloz. It's pronounced Jaloux, French way. Do any of you know the migratory patterns of certain birds? Hummingbirds or ospreys, like what they do to come up to these areas time and time again?
Yeah, it's just if you have comments or questions, just,
No.
we can't really respond.
No,
Yeah.
okay, sorry. And I can't speak in public, so please, I apologize. All right, so ospreys, for instance, when they migrate up here from South America, they fly by themselves. They mate with the same birds throughout their lives, and they come to the same nest year after year. And I don't know if there are large bodies of water, on the property, but I know of some nests in the area. Hummingbirds, they fly up from Central America. When they fly up, they cross the Gulf of Mexico in one day. The only way they rest is on oil tankers. I have the same hummingbirds come back time and time again to my house, and I'm afraid that with all that's happening, it will definitely impact them. The biggest thing for my family is my daughter. She has a very rare genetic condition that affects her NaV1.6 sodium channel in her brain. She has severe seizures. She's one of 7 children in the world, and I'm not lying about that. It's a de novo mutation that did not start in her parents. We fight time and time again to get what she needs in school. I have multiple sclerosis. I'm tired of fighting, and I'm tired of worrying about things and what this is going to do to us. Like if we want to take her out walking, it's just scary. And I know you have a very hard job to do, but I just worry about what it's going to be like for my daughter. I want to stay here. We've fought so hard to get what she needs in school. I don't want to move. And we've been here, 20 years. So,
Thank you.
Hello. My name is Teresa Ellis, and I am in a butter. I live at 27 Keith Drive, and I just want to express my opposition to this project. I grew up in the city. My husband and I built our home here 27 years ago. We were drawn to this area because of the rural nature of the area, and our spot that we live is on a cul-de-sac at the end of Keith Drive, at the corner of Lisa Lane, and this project does directly abut my property, and I share the same sentiments as many of my neighbors who spoke here tonight, the concerns that I have regarding the noise, the potential health risks, the cutting down of all the trees. I feel like from my backyard I'm going to be able to see these solar panels. So I'm very concerned. This is a property that we take a lot of pride in. My husband and I just made a major investment, financial investment, where the home is 27 years old. We're putting a new roof on, new siding, so we're making a financial investment in our property. We want to stay here. I lost one of my next door neighbors, and it was directly related to the solar project. Her and I came to one of the earlier meetings last August By September, she was so outraged by it, she had her house on the market, and by November, she was out of there. Somebody else new was living there. Lost, a very nice neighbor. There have been other people in my neighborhood who have also left for some of the same reasons. So I just want to say that I'm opposed to it. I share the sentiments of my neighbors. Thank you.
Thank you, Teresa.
I'm Lisa Hopkinton. I live on River Meadow Drive. And I'm a little concerned, in listening that you're asking us to believe that everything will just be easy to be switched back to residential when everything is done. But we asked you to accept a comprehensive plan that was going to keep our homes in a residential area. And we're struggling now because that may not happen. So how can we trust that something that's 25 years away, but again, I probably won't be here either, to what it is, we can't trust. Well, anyway, I'm also concerned about the wildlife. I live right on the Wood River. I came here 30 years ago because I love the wildlife and I see it all the time. And, we're a town that I like to think, gee, there was an osprey that got cut, that was caught up in a fishing lure, and the Hopkinton Fire Department came out and rescued the osprey. This is the kind of town that I want to live in. And when I see, vast solar arrays going up, I don't see how that fits with the osprey and the wildlife in the area. I also just have a feeling that when I look at all those solar panels, it just is like a massive asphalt field. And I wonder about what it will do to the temperatures in the area. Can an engineer answer that? Does it raise the temperature a few degrees? Will it change the forests in the surrounding area over a period of time? Anyway, those are just some of my concerns. Thank you.
Thank you very much. Look at time, I guess we
Jason Taft, 33 Fenner Hill Road, also 12 River Farm, Idaho. I think the biggest thing here is everybody keeps coming in here wondering why the solar's coming in this area. It wasn't the farm for the large landowners and the farmers. They kept all this land through the good times and bad. We would have had these discussions. All these people here, they all want to talk about, there's going to be houses on 145 Skunk Hill. There's going to be solar on 145 Skunk Hill. That was my grandfather's farm. All them houses that you see on Lisa Lane and on Dye Hill, that's all on F farms. There were farms around it. None of these farmers and landowners complain about the houses coming in at all. Everything's time for change. Farming's out. If you look at all the solar projects that have been approved, it's all farmland. Or it's open space land that these people hang on to. They're all at the same age. They're all around retirement age. All the people on Lisa Lane want to look at the farm. They go out there and help them do the hay. I didn't see anybody help my father keep it open space and be farmland. So they moved here, they lived on Lisa Lane, look at that beautiful view. If you go up in Connecticut, in Glastonbury, Colchester, they charge you for that view. You see the view of the city, you get charged for it. Everybody wants to keep going on and on about solar, farms, and everything in the town. It's just kind of crazy. So I got a little article that the speaker of the anti-solar put in the paper about it. I'll give it to you guys so you can read it. It stated that I went around to all the abutters, which I only went to one. and told him that there is a plan for Gordon's property that's affordable housing. My father's land, which was 145, was approached by Concerned Homes. They would have put 37 houses just in the front in the field. Leave the back as open space, and they wanted to do the same. If you read the article in the paper, it states I'm untruthful, and I lied to the people and said there was no plan. Then if you read all the way through the article, it states that I only have 2 corporations in the town. I have 3. The other one's Tall Timber Farm, which I just bought 100 acres to put 1 house on. I'm preserving the town of Hopkinton by putting 1 house in. I could put 40. But here's the map that your anti-solar speaker said wasn't recorded to the planning board. And you see it in 2005. If you read the whole article that the speaker of the anti-solar put in here, he states in here all the dates. 2007, 2008. The landowner was smart enough not to put this on because he would have lost his property because it was overwhelmed with affordable housing. You read the whole article, he states how all the affordable housing, how busy he was at that time. But I don't appreciate anybody putting in the paper that I'm a liar. I'm not a liar. I didn't lie to anybody here. There's a gentleman here that I told him my father already sold the property and I own the wood. Them trees are going to get cut regardless. If you want to talk about trees, I did all the biggest habitat projects in the state of Rhode Island. I cut 24,000 trees off of Prudence Island for habitat. If you want to see the other one, it's at Guerrillas Preserve. I cut 37-acre clear cut. There's 5 trees standing. This was all funded by NRCS, by the government. And you're going to see a lot of the landowners throughout the state of Rhode Island, they will have habitat cuts all on their property. They get paid by the government to do this. So everybody's telling you about cutting trees and why we're cutting the trees. There was a study done 3 years ago on the logging business. We weren't cutting the trees fast enough. They were growing faster than we can cut them. And then you come in here and everybody comes in for the application for solar. First thing these people want to say is 6,700 trees coming off that property. I didn't see any one of them. They come in, there 5 trees around the house, come in front of you, and say, hey, I got 5 trees to take down, and I take them down. You build a house, a barn, a shed, nobody's coming in front of the council, writing down how many trees they got to cut before they cut them. Mother Nature, you can't do nothing about it. Everybody's complaining about solar, you'll be the first ones to complain if they lose their power. The other thing I like to say, this is our town council. All you people pay taxes here. I've watched this for 2 years. All these anti-solar people come up here and attack every single one of you, somehow. They have to realize, you guys are residents here too. When I was brought up, it's called respect. It's very disrespectful when people get up here and attack every single one of these people on the council. All these people here got to realize one thing. You are our elected official. You can look at anti-solar 500 people. You can look at pro-solar 500 people. That still don't even give half the votes that you guys have. What's the least amount of votes you have? 1,800? There's a silent community here. I put the petition out because of the silent community. Everybody wants to read the petition on it. When it gets down to keeping citizens in the home, they don't want to read it. They only read half of it. Everything they read is halfway. They let all these people's minds just run. You got an attorney sitting here telling these people. Nobody gets a second opinion. It's unbelievable. But I do not like all these anti-people coming up to you, the 2 speakers, and attacking you personally. That's not what it's about. The council still lives in this town. Thank you.
Thank you. Walter, 1 second, Mary. Okay, one more.
Sorry, last week? The last
Walter, 60 pages.
Never spell it right.
No.
Just wait a minute.
No, go ahead and spell it for us, so we'll finally have it correct.
C-Z-E-R-K-I-E-W-I-C-Z. I've always lived on a big piece of land, my choice.
Well, to speak clearly into the microphone.
I've always lived my whole life on a big piece of land, by choice. I'm not poor, but I'm far from rich. And I like these people, I like to look at trees and I like the view. I like to look out of my kitchen window and I get a beautiful pond, trees. And it's going to stay that way because I control their mind. But I have to pay taxes for that privilege. These don't come through with somebody else's view on somebody else's property. I've been here most of my life. I have a lot of things I want to say. I probably figured half of them. Water and panels, as far as the aquifer. Septic system is a lot worse than that. Gravity pulls them all down. Some may pull some of them up, but not really that. Now, Tom, you people also have the responsibility for the fiscal health of the town. The more houses we get, the more taxes are going to go up unless we got something to counterbalance, which we need. When we build houses all over, wildlife's not going to be around anyway. And when we build houses all over, it's not going to be rural, it's going to be suburbs. I guess that's about all I got to say right now.
Okay, welcome. Thank you. Take a 10-minute recess. Okay, folks, I want to continue the hearing. We had, I think, a couple more folks that wanted to speak.
Want to go to the floor?
Joe Road, Old Depot Road. Recently there was an article in the Sun, and it was headed, "How did Hopkinton get here with solar?" And it was by Rosemary, who attended most of the Old Depot Road hearings. And the reason why I'm mentioning this is that it really ties in with this type of project as well as Palmer Circle. Basically what Rosemary said, that the residents who live in the 64 condos and 5 homes on Palmer Circle are the unfortunate ones. The land on Palmer Circle doesn't need a zoning change. The zoning was changed back in the 80s from residential to commercial when Foxwood was thinking of building a hotel. The hotel was never built and the zoning remained commercial. The zoning remained commercial. Commercial is the magic word to build these solar farms. No vote needed, just build it, don't worry about the aquifer, it's okay. Runoff, we got it covered. Property value, everyone wants solar. The incentives from the federal and state government have developers from all over the country eyeing Rhode Island land so that they can build these energy-producing giants. Yes, removing trees and replacing them with metal panels and green technologies. How did we get there? My guess is the projects that were not approved in years past in the school budget, which crippled cities and towns in Rhode Island to the point where they are approving these eye-candy solar projects. We must fund the school budgets regardless of the irreparable consequences to the land. We may go back and forth with these solar changes. We are learning to live with our new metal neighbors. Get ready. There's a solar farm coming to a neighborhood near you. I thought she had a lot of great points there. As Rosemary said, we should not be fighting about zone changes. One project on Palmer Circle near Rosemary has been clear cut. And I would urge everyone on the council to take a look at that project. Oh, I made a mistake, I cut too many trees. It's too late. They just clear cut every tree that was on that property. Another project near her is in the development stage by Oaks Grade Developers. A third piece of property that the tribe owned that she referred to was recently sold to a developer from New Jersey. Who knows what will be built there? That project was, the project that was defeated on Old Depot Road was listed as special commercial limited to solar and will revert back to residential after the solar was done. The question about the reverter clause is still being questioned. Now, on the agenda for this project, and I don't know why, all of a sudden it says from 80 to commercial. No special commercial, not limited to solar. It's going to commercial if it's approved. The Sun article said zoning was changed back in the 80s from residential to commercial when Foxwoods was thinking of building a hotel. The whole hotel was never built and the zoning remained commercial. The residents of Palm Circuit are paying for that now. Skunk Hill Road project has been listed, as I said, as being changed to commercial on the agenda. My question is, if that project is approved and they put in solar and it's commercial and they go bankrupt, it's zoned commercial. Anything could be put on that property. It could be a construction company. It could be a bus terminal. It could be a convenience store. It is zoned commercial. This town council was elected by the residents of our town. You all took an oath when you were sworn in to follow the town charter, the comp plan, and listening to the advice of our planning boards. Why are some members of the town council not adhering to the land use goal 1 and 4 or housing goal 1? It was mentioned by the attorney. We need to follow the comp plan. We need to follow our town charter. One question I have is, why are some members of this town council not listening to the majority of the residents who have attended these hearings and are opposed to changing residential property to commercial? That's not consistent with our comp plan. The attorney mentioned that this project would be based on the comp plan. It's definitely not consistent with our comp plan. This is a prime example of spot zoning. I know there's been issues about spot zoning. This is the worst example of houses in a developmental area for spot zoning. There isn't, someone mentioned it, there isn't any zoning commercial for miles and miles from this project. Look at the number of houses. It was mentioned tonight, and I know we heard the same thing on the Old Depot Road project, that the attorney referred to a trust that was going to be given to the town, and I can hear Vinnie today saying the town can do whatever they want with this gardening property. He referred to it as the gardening property. So I'm not sure if that's the property that's coming up. When there was pushback from the residents, that's when you'll see concessions and requests to give them back to the town. You know, they mentioned about moving it back 300 feet. I'd like to see you move it back 300 miles. It's residential property and you're trying to change it. It's against the comp plan. The residents, the majority of the residents have spoken. We go through all these meetings since last July, and in my opinion, the basic thing is you get an opinion from a planning board, an advisory opinion not to do this. All you need to look at is the comp plan. It's not consistent with the comp plan. Why go through all this? It's just residential property to commercial property is not the way to do it. Last thing I want to say is, maybe you weren't raised in a house and you didn't have kids. I don't know. I'm so tired of hearing children are a burden to our town.
That's right.
People move here to raise a family and have children. There's 13 houses on my road. There are 6 children in the entire street. 2 of those children are seniors. They're not a burden in my mind, but to other people, children are a burden. And it's unfortunate. Thank you.
Thank you.
Carol DeRoche was Pleasant Drive. I guess the first thing I just want to reiterate is we had the attorney for the developer state that the question before you is really, does this align to the comprehensive plan? I am troubled why we have spent almost 9-10 hours already going over details of development plans when this is supposed to be a discussion solely about whether or not it aligns to our comprehensive plan. I don't believe it's the town council's job to be doing master plan development. I also want to make a comment about, I think someone said something about paying, other towns pay for their beautiful views. Well, in this neighborhood, if you look at the Gordon properties, property tax, it's $5,156. If you look at the Scout Hill property tax, it's $5,777. If you look at the average property tax of the abutters on Francis Barber Road, they're paying $6,370. If you look at the average property tax of the abutters on Lisa Lane, their average property tax is $6,620. If you look at the average property tax of the abutters on Beverly Ann Drive, theirs is $6,805. So the large landowners are not paying more taxes than the people of this neighborhood that might be destroyed, and those values come down. The last thing I want to mention is I don't understand how the town council could trade a property, this property, for another one, and that how you could equitably pick who gets to have their property purchased and put on conservation. Can I get in that lottery if I have a landowner, a large land? Shouldn't everybody be considered for that? How can you pick a particular plot of land to get that golden ticket?
Thank you,
Dorothy Gardner, Canachigrick Lake. I'd like to give you a few views on the other side. Those of us that are pro-solar, and also those of us who don't consider children a burden, but realize that we need tax revenues coming into the town to pay for their education. I live on a fixed income, and I'm not complaining, but that's how it is. And if homes go in instead of solar, my tax burden is going to increase tremendously to the point where I won't be able to afford to live in Hopkinton. I won't be selling my home because I don't like solar. I'll be selling my home because I can't afford it anymore. So there's a big difference there. Another thing I wanted to talk about was the difference between the planning board and the town council. I'm going to put this very simply. When I was an adjunct professor and I taught critical care, I tried to take complex ideas and make them simple. My understanding of the planning board is that they look at an area kind of like through a spyglass. They look at that area, they look at that plan, and they decide if they like it personally or if they don't like it personally. They can see it from the air, or if a car driving to Boston or New York can see the peaks of a solar farm in their windshield or in their rearview mirror. Whereas the town council has to take the town as a whole. They can't just look with a spyglass here and a spyglass here. They need to look at all of the people and all of the town. And they need to say, for the good of many, there may be a few who do not like our decision. I do not believe that the majority of the people in the town of Hopkinton object to solar. I think that the majority of people in the town of Hopkinton would like to continue to live here under a tax base that they can afford. I don't think it's at all a question of yes solar or no solar. One other thing is that I've heard people say that, I moved here and I love this view. I look over there and I see this field and I see a barn and I see a red farmhouse. And it is beautiful. It really is nice to sit there and have coffee and look at somebody else's land. But if you like it that much, what you have to do is buy it. Landowners can no longer afford afford to keep land so that their neighbors can look at it. It is just too expensive. And I say that because, I mean, I have some land, and it's very difficult for me now to keep it, and in the future, it's going to be sold. Just for that reason, I can't afford it anymore. It's a luxury I can't afford. I own the house that I live in for over 60 years, and the land that I have adjacent to my home, I've owned that from the early 80s. I never even lived on it. My parents lived on it. We did our best to keep their house up. We have a small cottage there where a man now lives and keeps an eye on the woods for me and throws the hunters out and helps me with heavy tasks. But soon that would be gone, only because, I mean, I can't afford it. It has nothing to do with solar or no solar. It has to do with my increasing age and increasing taxes. But I would ask that you look at the whole picture and you look at the community as a whole. Thank you very much.
Thank you, Jennifer.
Well spoken, Josh. Jeffrey Gilman of Valley. I wish I could have came up there like 12 people ago. But the subject came up, you asked some very great questions. And sorry, I was one step ahead of you, but I called Vision Appraisal. And I asked them if there's any evidence of devaluation on properties as a result of the solar farms. And they said absolutely none to this point. So I know Eric Bibler is trying to do fuzzy math, trying to say that the tax revenues that you're going to get from the solar panels are going to be offset by a decrease in the assessment by the homes. He said that's not the case. So don't take my word for it. Ask the same question yourself. Thanks.
Yeah, 2 minutes. We got Steve and Bill who have not spoken.
Hi. Oh, I'm so sorry. Luann McCormick, recently. I would like to just follow up on that last statement. I was a realtor for over 20 years, and there's absolutely no question, zero question, that there will be a significant drop in property values, particularly for direct abutters or anybody that's in any kind of line of sight. Absolute guarantee. Thank you.
Bill Bergen, High Hill Road. I'm just going to rebut Luann before I start. I apologize, my voice was shot from allergies. But there are 2 studies done in Indiana and Illinois that absolutely refute what she just said. Both the studies, I believe I sent to the town council about 3 months ago, that show there is absolutely no loss of value to anyone that moves into or lives near a solar array that is commercial. Just what it is. But to me, this whole problem is really about how you take care of all the people in this town. Not just the 75 sitting behind me, that are all financially well off, all very well educated, or somewhat well off. Well, if they live in Hope Valley, their house values are $300,000 to $400,000. If they live in Ashley or Bradford or Hopkinton City, their average house value is going to be $200,000 to $250,000. I venture to guess that most of the people sitting behind me live in Hope Valley. I'll end it there. So now you have a whole bunch of people in the rest of this town that don't have a lot of money. Okay, the average income in Bradford is $56,000. They're not doing too well in their taxes. There's a lot of people in this town that are single parents with 2 or 3 kids. They don't have enough money to increase the taxes. And what's going to happen in this town to the elderly? Same thing. Increase taxes, the elderly are going to suffer. All right, so with the amount of land that this town has, what eventually is going to happen, and we're talking a 20-year plan for solar, all right? In a 20-year plan for housing, all the free RF80 land is going to eventually become housing, or a major portion of it. And when that happens, the town will not be able to afford the good school that it has now. It happened to Exeter, West Greenwich back in the 80s when they built their new high school. They had to cut all kinds of programs. The kids all suffered. That is what will happen now. The reason people don't see a lot of kids on the streets where they live now is because they're all older neighborhoods. The lady that said before, she only sees 6 kids in her neighborhood. That's right, all those kids have gone. Sawmill Road has 5 house lots, 4 of which have housing permits pulled on it right now as we speak. One of the houses has been sold, another house has been built, the sale is pending on that one. There have been 27 single-family, multi-bedroom housing permits pulled in the town as of 2 weeks ago, all right, since January of 2018. Just that alone. Children aren't a burden, but they burden the tax base when you have a lot of kids in school. And they're going to come. If you build the houses in this town, they're going to come. The builder that's building on Sawmill Road, I asked him, why are you building them? He said, because if I build them, somebody's going to buy them. And they're all 3 and 4 bedroom houses. So there's 8,000 people in this town. There's 6,500 registered voters. I don't see 6,500 people behind me. You didn't listen to the people that were the abutters on the Brushy Brook project. So I think in due course, you should give the people behind me that live on the Skunk Hill project the same consideration. Don't listen to them. And when it all boils down, you represent all of the people of this town, not just the 75 that are behind you. Thank you.
Thank you.
Good evening. I know you guys are tired. You probably don't want to hear anything. Can you hear me? Yeah. Okay. I don't even know where to go on that.
Steve Brophy.
My name is Steve Brophy, 54 Signal Lane. I just wanted to, I don't even know where to go on to comment on the last individual who just showed up. My problem with this is I keep hearing about the silent majority. All I see every time I come to one of these meetings are these people here who show up, who come out at night to show up. And I would say about 99% of the people here are not for this solar development that's going on. So, as far as the silent majority, I hear that argument constantly. I don't see it. If they're silent, they're definitely staying at home and not coming here to voice their opinion. Maybe a few people. My other point is that I was also a realtor, and I know for a fact that these guys are going to get hit drastically as far as the value of their properties are concerned. When I was in realty, I was showing a house that was being built in an area where they had high tension lines, and actually what was left of the nuclear facility down by Charahoe. And also there was this Superfund cleanup site that was also near them. And I was told basically not to mention, but in good conscience, I told the people, I said, hey, they said, this looks like a nice area. What are those high tension lines over there? I said, oh, they're just left over from the nuclear plant that was built over there, that's now been plowed under. And they couldn't get in their car and leave fast enough. So I can tell you right now, property values can be hit very badly. So I don't know where the gentleman said that they weren't going to be drastically reduced. They will be, and these people are going to take a hit. And for people who came in and bought their houses and wanted to see an increase in value, well, I'm telling you guys, honest truth, that's not going to happen. They're going to take a hit. And that's up to you, whether you want to allow that. Thank you.
Thanks. Real quick, because we got a couple folks that have not spoken.
I know. I just want to, that issue about the Indiana, Illinois thing that they sent, there were 3 houses that they looked at. 2 went slightly up that they thought were comparable, and 1 went down. I'm a scientist. don't make a plan and say, this is what I'm going to find out, and I base it on 3 properties to look at. So when you read an article, make sure you read the whole article. Okay, thank you.
John Padula, Valley.
John Padula?
Yes. And I just, I attended the last meeting, I've been keeping up with the articles, and I've been keeping track of concerns that haven't been voiced. So ideally, all of these concerns should also be compiled into a future solar development questionnaire to be completed by developers demonstrating their literacy on the topic and knowledge of current planning for their 20-year utility target
Can you
sites.
talk a little slower?
Yes. So, question overall. So I have 4 sections. We've got trees, obstacles for future use, energy, and the 20-year concerns. So trees, just real quick bullet points, is what is the cash return on the harvested trees? We're talking about 60+ acres. Trees are an amenity. They're used for things. What's the end use? Who was the company used to clear the trees? What's their affiliation to the developer? Because there is a cash return potentially involved. What's the effect of the previously forested and now severed tree roots cast in the shade and having their energy from the sun redirected to solar panels over the course of 20 years? A couple silly ones there. And 20-year concerns. What is the maintenance program for the cleaning of panels? I know when I park the car outside, tomorrow there is pollen covering the whole thing. I'd imagine pollen would also interfere with the energy collection. If one panel fails, are they wired like Christmas lights? Who's going to come out and fix the single panels? What's the location and the body number of the maintenance crews? How is commercial solar collaborating with residential? And this is a big one because I don't know if you guys see it all over the internet, but there's 10 companies that want to come install panels on your house and give you rebates in conjunction with all of these commercial areas. So it's not one or the other, they're everywhere. They're coming out. Let's see. Why is there such a discrepancy on the kilowatts generated per acre? It's not like 1 acre equals this many kilowatts. You have many sites, similar acreage, generating massive amounts, or smaller amounts. Natural disasters. Many VOCs are used in panel construction. How will the sites decommission and clean up the sites if they become damaged on that scale? Or just in general? What's the actual step-by-step plan? And then, not so much 20-year concerns, but 25 years of shade doesn't do much for the soil beneath it. So, on an energy section, because I specialize in electrical, and that's what I like to think about. The operating voltage of the panels and the current of them should be known. The operating voltage of the transformer and the inverter should be known. There should be measurements for the infrared, the ultraviolet energy, and the decibels. I have heard from the last meeting, noise levels are silent. But there's another concern, and that deals with electromagnetism. EMF, EMI, EMR. That's frequencies, interference, and radiation. So that should be measured over 24 hours on an existing site to know these things. They have tons of issues that they can cause. What is the overload protection built in? How soon can the certified emergency crews arrive to disable arrays if something happens? And the measurement of energy collected versus reflected by the panels, because despite being in the modern age of technology, they're still known to reflect far more than they collect. Photons kind of bounce around. They don't really settle, so they go with the wind once they come from the sun. Could the grid disruption cause damage to the array or the inverters or the transformers coming backwards into the solar arrays? And we're currently at the lull of an 11-year solar cycle. Our sun has years too, it's about 11 years to every 1 year. So the activity will heighten about halfway through this arrangement. Solar flares are known to damage electrical components all the way down to your computers, all the way up to grids. We don't know what's in store for the future. And just obstacles for future use, the fertility of the topsoil arises again. surface integrity after 20 years of decaying root systems. I don't know if there's good examples of cutting a tree in half, because a tree is actually as much beneath the earth as it is above the earth. But when you cut the top half off, it's kind of taking the grain away. So they don't absorb properly. We don't really know if fungal decomposition or bacterial decomposition will take hold instead of photon decomposition, which is a natural course. And the quality of future well installations happens to be 75 to 150 feet. That's about the height of trees. So if you go from the ground down, that's the depth of the roots. The roots become contaminated fungally because they're not getting the sunlight. Because they're in the shade. What may happen? That's all I've got.
Okay.
Hi, Lynn, I'm here, 100 Maxon Hill Road. I just want to state for the record, I am really tired of coming to these meetings, and I'm assuming you're going to get really tired of me talking about this stuff. I have bought another project, and I see no way to sell my house, so you're stuck with me. As far as this 6,500 residents that you represent, and there's somehow just a measly 75 that show up, a fraction of this showed up for a Second Amendment resolution thing that you guys had no problem passing. I want to speak to the lawyer here who, with all due respect, you do not understand what we're feeling. It's not being frightened of change. We're resentful. We're resentful that we are stuck trying to pay for schools and you've cut off our funding. We're tired of being strangulated by it.
And just address the board, please.
Okay. I'm resentful that the only time...
Hold on one second. Sure. Okay, thanks.
Thank you. I'm resentful that the only time that Providence knows we exist is when somebody hands them a fat stack and a bad idea. There's a solution to the problem with the school funding, and it's sitting there. And it was used as a threat the last time we were here. That there's more legislation coming down that's being pushed by the General Assembly, so you better find some way to deal with it. I feel like that's just a really bad idea all around.
Right, thanks. Very quickly, Walter, we're at 10:01.
I'm part of the site and I'm also a large landowner. I pay less than $6,000 a year on taxes. But in order to do that, I have to be in forest management plan, and I have to do it with state code, and it's a tremendous amount of work. I'm not a mental patient, but I do know $6,000 does not even begin to cover one child in education.
Thanks. Yeah, very quick, we're over time, guys.
You have 45 more people on the petition for as far as the trees go on this project, on my company owns it.
Can we give that to Lisa?
2 minutes.
Very
1
quick.
minute.
All right, we have 1 minute, we're over time, Carol.
I appreciate that. Thank you very much. This isn't, excuse me, can you give me Carolyn Light, 43 Horseman Drive, Rhode Island. I've had the pleasure of watching the town council struggle with how they were going to make budget work this year. They worked really hard at it. One of the most important statements that you made to those who chose to be present for some of the discussion was that the increases to our property taxes in the 2019 year are a direct result, and I'm paraphrasing, I'm using my words, of Hopkinton being stuck in a warped, evergreen relationship with the Charahoe school system. Our council manages our money really well.
We can't fight what's going on in Providence, and we have no leverage over the school system. What's happening with our budget isn't a threat of children. It's because things are being taken away from us, and they're being thrown at us. And I don't have children, and I love paying my taxes, and I think that's a sad place for us to be. We have to talk about the burden of a child, because that's what makes us feel good. That's not where we're at. Scott mentions it frequently. We have to pay more attention to what our legislators are doing to us with our education. And we shouldn't be sacrificing one child or the quality of their education. I'm sure every taxpayer in Hopkinton feels that way. I agree with Jason Taft. We do need to respect our town council. But respect is also a two-way street. All of the organizations, all the people who keep this town moving forward, that is the taxpayer, that is the council, that is the planning board, it's everybody who are collective group. We need to respect each other because we've all tried really hard to keep this community the way we want it to be. Lastly, I made a commitment to the town council and to my neighbors that I was going to do my best to represent the town and make informed decisions as an alternate on the planning board. And there's been a little bit of activity over the last week that hasn't been so pleasant for a lot of people. And I can imagine what it looks like if you're standing on the outside and you don't understand the intricacies of it. When that event happened, I questioned myself, and I said, do I want to follow through? What the heck am I getting involved in? I made a commitment to my neighbors, to the town council, to the planning board, that I was going to be interested and I was going to help make informed decisions that were going to make us all feel good at the end of the day. And I could have withdrawn, but I am reaffirmed. I think there's some quality people in our community, and if you stay focused on the right thing to do, you're going to get there. And it's not through name calling, it's not through threatening people with school budgets. All of us need to make the right decisions, informed decisions. Lastly, my concern, whether it be a solar project or any commercial project, is that once the development team gets the okay to forge ahead and follow through with the plan that they have presented and has been approved, we don't have resources to manage the wrecking ball. That's what's hurting the ability of the residents to agree a little bit more about these solar projects. Because you have a calm circle, because you have a landowner, when they were clearing the trees, they cleared some of his trees on his property. It's not the landowner's fault, it's not the town's fault, it's the project manager's fault, but we can't manage those catastrophes. And I'd like to know that these promises that are being made by the developers, regardless of the type of project that they're going forward, and it happens to be solar this year, that they keep their promises and then handle the property, the property lines, the commitments to the abutters, the commitments to the town. There's going to be some way to make these people follow through on those promises and not make the catastrophic mistake of removing 25, 30, 50-year-old trees and say, oh, you know, I got your back. I can fix that. How do you fix that? That's my concern. Okay? And that's really all I have to say. And thank you for giving me the extra minutes, guys.
We have to make a decision whether we're going to close the hearing and set a date for a decision or continue it. So,
I make a motion that we close the hearing and make a date for the decision.
Second. Motion made and seconded, Lisa. And what are your thoughts? I know Meredith needs about 2 weeks for the transcript to give Councilor Capalvo a chance to review what happened tonight. She was sick tonight.
So you'd like to stick with a Monday night?
Yeah, I think it seems to work out.
I don't know the evaluation
6:10, that we have a meeting on, I believe, on that date as well. Okay, so motion made, second, we set a date.
Before we vote,
Yes.
Before we vote, I have one last question for the developer. The question was, what is your, if this goes forward, and actually it might be better Jason answers, but when this goes forward, if this even goes forward, which way would the logging, which way, what are you going to do with all the debris, all the branches? I don't want to know that. And what is going to be the exit? Which way are you going to exit from? We need to know what neighborhoods are going to be affected by logging and tree removal or log removal.
There's an existing log bridge right now that's permitted from DEM, which is where my father's house was down the back, Murray Brook, that entered from his driveway.
Okay.
And if we can't come through the field, at the end of the field, down at the end of the road along the field, it might be there, but most likely it's over the wall. It's not killed again.
Okay, but the,
Won't be on these lane or what?
Okay, thanks. So we have a motion made and a decision on a decision period for June 10th in Hopkinton School, 6:30. All right, I guess that's it. All those in favor? Aye. I need a motion to adjourn. All those in favor? Aye. Thank you. Good night, everyone.